All right, welcome everybody. Today's call is going to be focused on labor law, and we have our friend Jason Pill with us. Seems like most people are ticking in or already here, so we'll just launch right in. Our agenda today will be fairly similar to our previous calls. I'll give you a little overview of how to use Zoom and where we'd like you to be asking questions. I'm going to cover some really basic ground rules and give you a quick definition about some of the terms we're talking about today, and then we'll hand everything over to Jason to share his thoughts and give you some advice for these tough discussions you guys are going to be having discussions and decisions you guys are going to be having to make over the next few weeks. When you're using Zoom, you have the ability to chat with each other. Make sure that if you want to chat more broadly, you change the to drop down from all panelists to all panelists and attendees. That'll make sure that everyone can see your comment and not just the CWA team. For any questions you might have, Jason's giving his presentation, just type them into that question and answer box. If you see that someone's already asked a question that you also have, just upvote it with the little thumb in the lower left, and that'll make sure that we don't clutter that too much and that the most important questions get addressed once we move into the question and answer portion. During this call, we also are going to allow people to raise their hand if they have anything they want to say or ask their question directly to Jason. So feel free to raise your hand and we'll try to call on you as time allows. If you do get called on after you raise your hand, you'll have a little pop-up. Just click unmute myself and then you'll be able to talk immediately. The ground rules are very simple. Just be polite and respectful of each other, the CWA team, and Jason. If you do get called on to speak, just keep your comments down to about 2 minutes so that everyone has time to hear answers to all of their questions. Keep any personal political commentary on Facebook and not on this call, just to keep everything moving smoothly. And if anyone is abusive or problematic, we will remove them to keep everyone's experience as positive as possible. As we move into Jason's presentation, we'll be using some terms. We talked about these terms on some of our previous calls, but just to make sure that everyone understands what we'll be discussing. Well, when it comes to staffing and the decisions you might be making with your staff in regards to this situation, some of the most common tactics will be layoffs, which are a situation where you terminate the employment of that person. So they will no longer be on your payroll. They'll be completely removed from your books. Reducing hours is not quite as common with full-time staff, but some of you may be going this route. You'd be reducing hours to limit your payroll exposure, but you do have different obligations to people that have reduced hours. Also important to note, in some states now who are rapidly responding to the COVID-19 epidemic, reducing hours can occasionally make people eligible for some unemployment benefits in a few specific states. And then one of the other really common situations that you'll find are furloughed employees, where people will still be employed by you, so you still owe them benefits and maybe some other things. You are still going to have them on your payroll taxes. You just will not be paying them, and they will not be allowed to do any work while they're not being paid. Jason Pill is an attorney with Phelps Dunbar, and he's graciously volunteered his time here to share his understanding of some of the best practices and common ways to address the current situation. He's a longtime climber. He comes from a gym manager background and has been involved in the climbing community on the legal side for years now. A lot of you have probably read his articles with our friends over at Climbing Business Journal. And many of you might have seen him speak at the CWA Summit in previous years as well. So without further ado, I'll hand it over to Jason.
Okay, great. Well, thank you everyone for joining on this. I certainly understand this is a very difficult time for a lot of gyms. From the recent CVJ information I saw, virtually every gym is closed. I'm honestly surprised if any are able to still operate at this time, or still be open to customers, I should say, based on everything that's going on. So the goal of this presentation is to give everybody some more information on some of the labor and employment consequences. My practice focuses on employment counseling and litigation, so that's my background, and that's the information I wanted to share with this group. Because we have a diverse group that's in multiple states, I'm of course going to focus on the more prominent federal laws. There's going to be some state laws that apply as well. I'll try to give a little flavor for those, but we're naturally going to focus more on the federal laws that are going to impact everybody. So, naturally when this first began, we were just looking at some time off issues, and now, of course, with all these gyms being closed, we're having to shift that analysis a lot more towards staffing considerations and, of course, financial consideration. The CARES Act stimulus package is still making its way through government. It got Senate approval last night, as I'm sure a lot of you may have seen, but we still are waiting for the House, and hopefully that will be coming very soon. So when we talk about some of the business options here, there's going to be more options available in terms of the small business loans and forgiveness options, but we're still waiting to get those details. Everything we have from the CARES Act yet is still preliminary. That's a little beyond the scope of this presentation, but it does have some employment corollary, so I just wanted to note that because obviously the economic factors are driving this heavily. So just pulling a quote recently from an outside article that I was reading about the gyms closing, the reality here, as you all know, is there's no telecommuting situation available. Unlike other professions, there's not much opportunity here for your workers to keep working. There are perhaps a few opportunities to have some of your operational folks there, and we'll talk about that, but of course, largely gyms are closed and shut down entirely, and most of you have sent all your staff away. It's one thing to send all your customers away. It's another to send your staff away. Some folks might be trying to keep setting routes right now, cleaning holes or things like that. So for the few gyms that are remaining open, you'll have a couple options that we'll talk about in terms of how to budget your workforce. And we'll talk about this a little more quickly because I know most gyms at this point are closing. But even if you're closed to your customers, there might still be some options where you can have your staff coming in. Like I referenced before, perhaps you want to take this time to reset your routes, to clean your holds. If you're a larger gym system, you probably have some amount of administrative staff. Perhaps you have an HR professional, somebody if you're accounting. It's going to depend, of course, on your own specific gym's needs. But to the extent you are still having any employees come in, whether or not you're having customers coming in, but if you're still having employees coming in, there's a couple options on what you can do to manage your labor costs. Of course, what most gyms have already done is you can cancel shifts. If customers aren't coming in, you don't need a front desk employee. You don't need a belay instructor, things like that. So obviously canceling shifts is one option that's already happened pretty heavily if you're still maintaining them on your payroll. We're going to talk about when you're getting folks off your payroll. That's going to be the next slide, or 2 slides from now. But canceling shifts is one option. This is much easier for your hourly employees, and I'll explain that in just a moment. Along the lines of canceling shifts, you can reduce employees' hours, so you can reduce the length of the shifts, you can reduce the scheduling, and you can do this for your salaried or your hourly employees. It just has to be done a little differently depending on which class of employee it is. And another option is to reduce your employees' pay. Unless you have an employment agreement specifically stating that your employee is entitled to a set amount of pay for a set time period, you're generally allowed to reduce the pay, notwithstanding any state restrictions, and really California is the primary state to look at. California always has more labor restrictions, but generally speaking, you can reduce your employees' pay. So if you have someone who's making a heavier salary now, but you want to lower it for the time being to keep them on payroll, or if they're coming in to continue working, you can look at options to reduce pay. You can do that on an involuntary basis and force it upon the employees. But the first approach would be, of course, to try to discuss it with them and see if you can agree on that. So if you do have staff that are still working right now, whether it's your admin staff or folks working in the background, so to speak, while the gym is closed, that's going to be an option as well. With hourly folks, the main consideration when lowering their salary is, of course, making sure they don't go below minimum wage. Now, hourly folks are also a lot easier to adjust. You can change their hours on a whim. Again, unless you have a contract for them guaranteeing a certain amount of hours, which I can't imagine any of you would have, it would be ill-advised. You can change their hours, you can change their salary, so long as you're keeping them above minimum wage. Now, your salaried employees are going to be a little different. Now, when I say salaried, what I really mean is exempt from overtime under the FLSA. If you have employees that are salaried right now, their analysis is going to be a little different, a little more nuanced under the FLSA. That's the Fair Labor and Standards Act. That is our federal statute that regulates wage and hour compliance. And the benefit of putting someone on a salary, as most of you know, of course, is if they work overtime, you're paying them the same amount. So whether they work 30 hours in a week or 50, you pay that same salary. So carrying that rationale through, if you're looking to reduce the hours of any of your salaried folks, you have to do it on a weekly basis. You can't limit their weekly hours. They're still entitled to the same salary. You can look at furloughing them. You can look at reducing their hours, but if you're doing that, it has to be done in 1 week intervals, and they can't work at all during that week. If they work 1 minute of time, that triggers their full salary for that week. So if you've got some salaried exempt folks, you can look at lowering their salary, and you can also look at essentially a furlough option where you take them off of certain weeks. That's the approach that most of my clients are looking at right now. And this is the folks I've been speaking with, they're evaluating for salaried folks. And another caveat for that is when we talk about the hourly individuals that can't go below minimum wage, your salaried employees can't go below $36,000 annually. That is the federal level to qualify for the exemption that keeps them exempt from overtime payment. So that's part of a federally mandated level if you want to keep that exemption, meaning they're exempt from overtime. So there's a few different considerations there. There's a lot of permutations. You can even convert salaried folks to hourlies and things like that. So there's some options there, but I understand that certainly at this point, most folks have laid off employees or are looking to lay them off or looking to furlough them because there's just no work to be done. But I wanted to at least note these options and explain that they're out there. And the final point I'll make on that, to the extent you do keep employees on, most states have some form of what's called a Workshare program or a short time program. I've pulled a screen grab here of California's version. And essentially, this is a program where you work with the unemployment office for your state to fill in the missing hours that an employee has when you reduce their time. So if you have an employee that normally works 40 hours and you're taking them down to 20 for a short period of time, you can work with the unemployment office to try to fill in that gap. Now, every state's going to have some slightly different procedures here, and it's generally something initiated by the employer, not the employee. So that's a little different than regular unemployment, but this is a consideration if you've got folks that you're keeping on staff, but you're reducing their hours. So if you're taking somebody who's normally working 40 hours down to 20, you might want to consider a work sharing program. It's also called, like I said, a short time program, and there may be some other jurisdictional names that apply. The nomenclature may vary, but the theme is the same. You're trying to fill in for folks that are having reduced hours. So those options all contemplate you keeping folks employed and of course, keeping them working to some extent. That may not be a practical solution for many gyms, not the majority of gyms. So I also want to talk about some other options here as we look at furloughs and layoffs. Now, Garnet explained that at the beginning and did a great job. That's your main consideration points here. When you're furloughing your employees, typically what you're doing is you're keeping them on payroll and not giving them any work for a certain amount of time, whether it's 2 weeks, 4 weeks, 6 weeks. You don't have to identify a precise period of time. Typically, when we send out furlough letters, we target a date, but always leave in language to acknowledge it may change because, as we all know, there's so much uncertainty now. We don't know when these local restrictions will be lifted. We don't know what's going to happen with this pandemic. So nobody can give a certain date right now. So if you're looking at a furlough, what you'd be doing essentially is keeping an employee on your payroll, but not actually giving them hours and not paying them. The benefit to this, of course, is they're still getting their benefits. Sorry, a poll just popped up on the screen. The benefit with the furlough is that they're still getting benefits. So if you want to keep your folks on a health insurance plan, if you provide that to them, dental, things like that, a furlough will keep them there. If you take that approach, though, you will want to check with your benefits provider, your agent, your broker, to make sure you handle that properly. Every benefit plan is a little different, so you're going to want to talk with your benefit provider before furloughing employees to make sure you have all that in place, because you have to work out issues involving the employee contributions. If they contribute to their benefit plan, if they contribute a portion to the premiums, for example, how's that going to get paid when they're not receiving income? Is your gym going to cover that portion? Are you going to set up a payment plan with them? So a couple different options with furloughs, but the benefit is that it keeps your employees on payroll. It helps you bring them back faster when you do start to reopen. Also, as I suspect a number of you may have seen already, there is some language in the CARES Act, that's the $2 trillion stimulus package that's currently advancing to the House, that suggests there be certain loan forgiveness and certain benefits available to small businesses that keep their employees on payroll. Now, we don't know all those details yet because the act is not official. We've gotten some indications what it may or may not be, but nothing certain yet. So I can't opine on that specifically, but I do encourage everyone who's debating this decision right now to follow the CARES Act, see what ultimately gets passed. There may be some benefits there to keeping your employees furloughed and keeping them on payroll, and possibly some help handling some of those payroll obligations. And then the final option, the nuclear approach, for lack of a more delicate term, is simply laying off your employees. Now, laying them off doesn't mean you can't bring them right back, but it just means you are severing your tie with them as an employer. They can immediately seek unemployment. Furloughed employees often can seek unemployment as well. Most jurisdictions allow that, so let me just clarify that point as well. So your furloughed employees should be able to get unemployment in your jurisdiction. Laid off employees certainly can. But when you lay off an employee, they're off your payroll. You're not providing them any more benefits, and they are no longer one of your employees. It's quite direct, of course. That reduces your obligations immediately. You don't have to obviously pay them going forward, but as you bring them back, you are effectively rehiring them. So there's a little more work on the back end when you start bringing folks back into the fold and then the gym opens and hopefully gets back up to speed. Obviously, we're late March now. Depending on how this plays out, if gyms are opening up over summer, that's probably a time we'll need even more folks with kids out of school, and often when most gyms have some of their biggest numbers of the year. So those are your two main options in terms of immediately lowering your cost with employees, and when there is no work to be done, whether you do a furlough or a layoff. It's going to depend on your specific circumstances, what your finances are, and depending on how you feel about the stimulus package that comes out, if you think you're going to be applicable for some of those benefits. And of course, the uncertainty here also makes it challenging, because it's one thing to furlough somebody for a couple weeks, but we don't know if this is going to be a couple months. Also, we're going to have to see what type of crowds come back to gyms once these bans start lifting. You'll obviously get your dedicated climbers back. All the folks who have been working on the home hangboards are going to come right back in. But are we going to see the same surge from the birthday crowds, the parents who want to try it out for the first time on a Saturday? We don't know how those crowds are going to react right away. So those are some of the main staffing options that everyone can contemplate. I know a lot of you probably have already laid off folks or furloughed them, but I just want to highlight some of those considerations to think about. Another issue to be mindful of is some of the OSHA considerations here. And there's only two, so this is just a brief point. If you are still having folks come in, you want to make sure you're taking all proper precautions. If you can get your hands on gloves, provide them to folks who request them on your staff. I know that's a tough ask these days, finding any of that equipment. But generally speaking, what you're most likely to deal with is the possibility of employees who refuse to come to work because they believe they are in imminent danger. They're afraid of infection, of getting the coronavirus. Well, it's certainly reasonable to have that fear, but under OSHA, it's only sufficient to not come in when you have a fear like that if you believe you're in imminent danger. And you can see the definition here. I'm not going to read the whole thing, but this is from OSHA, the OSHA Act, Section 13A. When we talk about this imminent danger, it certainly could cover something like coronavirus that talks about a danger that can be eliminated through the enforcement procedures of OSHA, but there's no time to get OSHA involved. And here, of course, we have an issue where you can't get OSHA involved to figure these situations out quickly enough. So if you do have employees that are objecting to work because of fear of infection, it potentially triggers OSHA. I will say most likely in a gym setting, you're probably not going to rise to the level of imminent danger. Now, it's entirely fact specific. I mean, if you have somebody who is a confirmed COVID-19 case in your gym, that's going to change the analysis. But if there's been no indication that anyone in your gym's been sick, there's no indication that there's any of your staff that are currently sick, then that's going to change the thought process there, and it's going to put you in a lower threshold that likely won't rise this immediate or imminent harm. So if folks do refuse to work It's likely not going to rise to the level of an OSHA issue to force them to work, but of course you want to be careful with your staff. You don't want to be forcing folks to work if they're uncomfortable. You might want to try to see if there's a way to solve that solution otherwise, and as opposed to just absolutely forcing them to keep showing up. Now, additionally, another question I've been handling a lot and just want to address with this crowd is whether COVID-19 is a reportable OSHA incident. And under certain circumstances, it is, but I don't think it's something that many of the gyms are going to have to worry about. Anyone with more than 10 employees is subject to the OSHA reporting and record-keeping requirements. That should cover just about everyone unless you're running a real small bouldering gym. And everyone should be familiar, or at least have a rough understanding of their OSHA 300 log, where you have to log these incidents. Typically, that's if somebody gets hurt on the job, and we're all familiar with kind of the more common scenarios of someone getting injured physically, but it can include something like this, somebody getting sick through a virus. But the key factor here is that it has to be a work-related injury. So you're only reporting this as an OSHA incident if the worker contracts the virus while on the job. And what I'm sure you are all immediately thinking is, how on earth would I ever prove that? And that's a great question that doesn't have a great answer. This is why I don't think you're going to see many people reporting these on OSHA logs, because it's going to be near impossible to prove where somebody contracted the virus unless you're an ER nurse treating COVID patients. But for a gym to be able to say, well, one of our employees clearly got COVID-19 from our gym, I don't know how that determination is going to be made. So you're only responsible if the case is work-related and someone contracted it while on the job. So I don't think that's going to involve many gyms, but if you do find yourself in that situation, and for whatever reason, there is a high likelihood, whatever those facts may be, that one of your employees did contract it by coming to work, then you would have to report it. So I think it's unlikely, but I just wanted to note that. So the big issue that I really wanted to address with this group, and something that I've had a lot of questions and concerns about over the last week, especially because it's only been out for a week, is the bill that was recently passed providing, for the first time ever, federally mandated paid sick leave and paid FMLA leave. So the name of that bill is the Family's First Coronavirus Response Act. You may have seen that, may have seen the headline, the FFCRA, just to spare that mouthful each time. That passed last week on March 18th, and it's going to have an effective date of April 1st, which is next week. And we're going to certainly dissect this bill. But what this means is if you still have employees on your payroll, they may be eligible for certain paid leave benefits. Now, these benefits will be reimbursed by the government through tax credits and other methods of getting the money back to the gyms, but you are having to pay the money out in the first instance for anyone who takes these leave benefits. So let's dive into that a little more. So the two main effects of this bill are to provide these reimbursable paid sick leave benefits to employees. And the employers, like I said, will be able to recoup this through tax credits. There is a little bit of IRS guidance out on this now, so you do have a basic understanding of how that's going to work. It's incomplete, but there is some guidance out now. The Treasury Department issued that last week. But the two types of leave are what's called the Emergency Family Medical Leave Act. So it's increasing somebody's ability to take FMLA leave, and for the first time, making it paid FMLA leave, and also requiring employers to provide paid sick leave. Now, both of these two leave benefits are only triggered in specific circumstances, which I'll describe, and they're very unique in how they're applied to the employees. So they're not one and the same. It's two very distinct benefits. A lot of people have been conflating them, and some of the news stories, when they write them up quickly, combine the benefits. But I assure you they are different. The caps are different at a monetary level, and the triggering events are different as well. There's also, in that bill, there were some housekeeping issues about changing the employer-sponsored health plans. So you may hear from some of that from your benefits provider. And the Department of Labor is in the process of issuing some guidance for us to better understand how to interpret and apply the FFCRA. I will tell you the act was passed very quickly, and it leaves much to be desired in terms of precision and clarity. There's still a lot of questions about it. The initial guidance came out 2 days ago. It didn't answer much, but the DOL has assured us it's going to continue rolling out more guidance on this. So there's a lot that remains uncertain, but there are a few things that we do know at this point. So the first element I want to talk about here is this new FMLA leave. It's what's called the Emergency Family Medical Leave Expansion Act. So we've been referring to it as the eFMLA. It's similar to your prior FMLA leave in that someone's getting protected job leave, but it's different in a few very important ways. Most notably, it will be paid leave for up to 10 of the 12 weeks. So the FMLA allows leave for up to 12 weeks for a qualifying medical condition. Most commonly you see this for maternity leave, paternity leave, injuries, things of that nature. This has now been tweaked, or I should say supplemented, to provide leave, and you can see it here in this highlighted section, where an employee is unable to work because they have to care for their child under the age of 18 because their school or daycare has been closed because of COVID-19. And as far as I'm aware, every school at this point is closed, and I can't imagine any daycares are open. So it's going to impact a lot of people quite quickly. Now, it's going to depend, of course, on the demographics of your staff and how many of your staff have children, but for those that do, this is going to be a potential source of paid leave benefits. Now, when we talk about the FFCRA, it applies to all employees, all private employees, I should say, that have less than 500 employees. So unless your gym has more than 500 employees, you're going to be subject to this act. And there's a small business exemption we'll talk about. There's still a lot of details about that, but despite early reports that anybody who has less than 50 employees can remove themselves from application of this act, that is incorrect. There's a method to seek an exemption if you have fewer than 50 employees, but we'll get into those details. It is not automatic. So if you are an employer with fewer than 500 employees, which is the vast majority of gyms, this act applies to you, and that means you will be required to pay these benefits for anybody who qualifies. Additionally, for those of you that dealt with the FMLA before, you may recall there are requirements that before somebody take FMLA leave, they must have worked for your company for at least 12 months and have worked 1,250 hours. Those requirements do not apply to this leave. It's much more generous. You only have to have an employee that's been working for your company for the last 30 days. So that's a major change as well. So for this type of leave, if somebody started just over a month ago, they can qualify for it. Now, when we talk about it being paid, it's only portions of this that's paid. So you can get, under this FMLA leave, 12 weeks of job protected leave. 10 of the 12 weeks can qualify for pay. The first 2 weeks do not qualify, the first 10 working days. This is where the emergency paid sick leave will fill in when we get to that. So that means if somebody has a child that they have to take care of, they're the primary caretaker and the child's out of school because of COVID-19 and the daycare is closed because of COVID-19, they can get up to 12 weeks of leave protected, and 10 of those 12 weeks will be paid. Now, they are not paid at the regular rate of salary. You are only required to pay the employee 2/3 of their regular salary, not to exceed more than $200 per day. Now, for most hourly folks, a $200 per day cap's not even going to get triggered, but that's the most you would have to pay. So if you have somebody that takes this leave, they're going to be entitled to 2/3 of their regular rate of pay. For you, it's just their regular rate of pay is very easy to determine. You're not dealing with tipped employees like waiters. That's where it gets a little more confusing. You can look at their pay over the prior 2-week period to get a quick gauge on it, and you pay 2/3 of that, up to $200 per day. So the total cap for any one employee is going to be $10,000. So 200 a day, 5 days a week is $1,000 times 10 weeks, $10,000. And then, of course, to the employer, for you as the gym owner, you'd have to recoup this through tax credits and a few other methods that way. Now, you also have to look at reinstatement. If you have fewer than 25 employees, there's a different analysis about whether you actually have to reinstate the employee. You still have to give them the benefits, but whether you have to reinstate them, meaning you have to give them the job back, is a little different if you have fewer than 25. But for everyone else, you have to hold that job position open. That's the main goal of the FMLA, is making sure that when someone goes out on a medically protected leave, they have a job to come back to. What this has done is not only expand the circumstances for taking that leave, but now, for the first time, provide payment for that. So that's the FMLA piece. The other piece that has garnered what I would say more attention and a lot of attention is the emergency paid sick leave. Now, some states already require paid sick leave. This is in addition to any sick leave you already offer. This is in addition to any sick leave provided by your state. This is a new standalone sick leave provided under the FFCRA. And under this sick leave, you're entitled to 2 weeks of paid sick leave up to 80 hours. So you don't get the full 10 weeks under the EFMLA, you only get 2 weeks here for any of these 6 categories. And you'll notice a little overlap here because while the first categories talk about an employee who is out for their own medical reasons, we do have categories that talk about caring for somebody else. And primarily number 5, if you're caring for a child because their facility has closed. So this is where you can actually combine the paid sick leave and the paid FMLA leave for a worker who has a child who has a child that's out of school or out of daycare, can get full payment for 12 weeks. You get the 2 weeks of the paid sick leave at the start, and then after that, the FMLA kicks in and pays the remaining 10. That's why the emergency FMLA leave does not pay the first 2 weeks. The plan was that the sick leave could fill that gap for folks who are taking off the time to care for children who are out of school or daycare. One note here is the first prong, the employee is in a federal, state, or local quarantine or isolation. The DOL has issued no guidance on that point whatsoever. So for those of you wondering, well, if my county or state has a shut-in order, stay-in-place order, does that qualify? That is an excellent question that has not yet been answered. There's CDC guidance suggesting that shut-in orders might not rise to this level, but we're still waiting to see what that will be, and we're still waiting for the DOL to clarify this point. But it remains unclear for now whether shut-in orders will satisfy this first prong of a local quarantine or isolation. You could certainly see an argument on both sides. So if you have an employee that's going to satisfy any one of these 6 requirements, that's going to trigger the paid sick leave for up to 2 weeks of sick leave up to 80 hours. If they work overtime, they don't get that extra pay. It's capped at 80 hours. And if they're a part-time worker, they're only entitled to the numbers of hours they would normally work during that 2-week period. So a 20-hour-a-week employee is not going to get the full 40 hours each week. That 20-hour employee would be capped to a total of 40 hours, 20 each week. So the amounts paid for the sick leave are higher and different than what is paid for the Emergency Family Medical Act leave. So the daily limits here will vary based on why somebody is taking the leave. If it's folks who are quarantined or experiencing symptoms themselves, they may be paid up to $511 per day. Now that is a cap. If your employee makes less than that, you pay them the lower amount. But these are just caps that apply. So this is really only going to get triggered if you have any highly paid salaried employees or folks on a much higher level in the company. Most of your folks that are hourly, they're not going to hit those numbers, so you shouldn't have much of an issue there. But there is a cap of that $511 per day, and then $200 per day if you're looking after a child. So that actually harmonizes with the Emergency Family Medical Act leave pay, also capped at $200. And these paid leave provisions, the Family Medical Act leave and the emergency paid sick leave, will expire at the end of this year. So obviously they're meant to target these very current and timely issues related to coronavirus. This is not going to extend into future years and provide these additional sick leave benefits. These are only coming up now to combat people taking off time because of coronavirus, COVID-19. So what you've got here is a federal act applying to everyone with fewer than 500 employees that is requiring you to pay emergency family medical act leave if someone cannot come into work because they have to care for a child whose school or daycare is closed for COVID-19, and paid sick leave for anybody who satisfies any one, and I'll get back real quick, of these 6 criteria. So for folks that you're keeping on your payroll, whether they're working or just staying on payroll, they're going to have an argument they're going to be entitled to this. If you lay them off, of course, they're off your payroll, it's done. They don't get these benefits. If you furlough employees, they're technically still on your payroll, but it's unclear at this point whether these benefits would get triggered because these benefits are based on the employee's ability to not come into work to either care for a child or because they're sick. If they're furloughed, there is no need for them to come into work. So there's a strong argument, and most folks believe that furloughed employees will not be entitled to these benefits, but I do note it is somewhat unclear at this point because this just focuses on whatever or whichever employees are on your payroll. So if you lay them off and they're off your payroll, it's clear it won't apply. If you're still giving them hours, it certainly applies. And for furloughed employees who are not working any hours, it likely won't apply, but that still remains unclear. So like I've talked about, unfortunately, a few times, there are a number of points in the FFCRA that remain unclear and without answers. And we're hoping to get those answers, and that's where the DOL is slowly providing guidance to its wage and hour division at WHD. The first piece of guidance just came out 2 days ago. It came out the late Tuesday afternoon. This is from the release that they emailed out. They put out a fact sheet and some questions and answers. The fact sheets weren't very helpful. The questions and answers had a few interesting points that we'll work through here because it does provide some additional context on how this law will be applied, but still, again, leaves open a lot of questions. So the DOL has committed to providing more guidance, but has not said on what schedule it will be providing this guidance or what the guidance will be. So we don't know what's coming or when it's coming. So I know that is pretty unsatisfying, but that is the reality. You can even see there at the bottom, it just says they're going to be coming out with more fact sheets and more Q&A. When and to what extent, I wish I knew. But for now, we do have a few points that are going to be relevant to folks that are keeping some employees on payroll or looking at the application of the FFCRA. So one of the questions is, what happens if I have fewer than 50 employees? We kind of touched on this a little bit before. There was some language in an earlier draft of the bill that these required paid leave benefits would not apply to businesses with fewer than 50 employees. As the bill made its way through legislation and ultimately got passed through the Senate, that got tweaked. Now, there is still an exemption for businesses with fewer employees if paying these benefits would jeopardize the business as a going concern. And that's the language from the act itself. It would jeopardize the viability of the business. The challenging and frustrating issue here is twofold. One, we don't know quite what that means. We can all argue that having to pay these benefits is challenging and will jeopardize the business. What level of financial hardship must you show remains unclear. The other issue is that you as the gym do not get to make that decision. The Department of Labor makes that decision. This was a key change in the bill as it got passed. Initially, it was going to be a self-executing requirement where you could make the decision, but ultimately what happened in the final draft of the bill is that the DOL was given the authority and conferred with the authority to make this decision, meaning the DOL has to exempt your business, meaning you have to apply in some form or fashion. And so naturally, this has created a lot of intrigue and controversy, and the DOL tried to handle it in the guidance that was issued 2 days ago, but you can see this is a cut and paste from their Q&A. It's a pretty unsatisfying answer. The Department of Labor is pretty much saying, we don't know what we're going to do yet. Just start collecting documents. Don't send them to us. Just collect them. Just gather your documents and just wait for more detail. So it remains unclear. Again, sorry to keep saying that, but it remains unclear how this is going to get applied. This is the most context that we have right now. So if you have fewer than 50 employees and you do believe you will qualify as for this hardship exemption, you want to try to document it now. Likely it's going to require some showing of your finances or lack thereof, and then wait to get this additional guidance on how exactly you'll go about submitting it. I suspect the DOL will create a separate department or location to send that information. Obviously, they're trying to avoid a flood of information coming in with folks applying for this exemption. So for now, you just have to collect the documents and sit and wait. Another question that came up, and we do have an answer on, is when we look at the various reasons that you can take the emergency paid sick leave, as you may recall, there are 6 different ones. And one of the questions that somebody poses, well, if I qualify for all 6, can I multiply and take all 6? Will each one give me another 80 hours? And the DOL clarified, no matter what combination of criteria you satisfy to take leave, you're only going to get the 2 work weeks, 10 work days, or 80 hours. So there is an absolute cap of 80 hours on that emergency paid sick leave, even if you qualify for multiple ones. So if you're quarantined and you're looking after someone and you're seeking a medical diagnosis, et cetera, you're not going to be able to bundle those all together and get more benefits. So the other question, and kind of explaining why the sick leave was drafted the way it was to interact with the Emergency Family Medical Leave Act, is to understand how will these 2 leaves be applied. And one of the questions that the DOL did answer is, well, what happens if I'm home with my child? Do I get paid sick leave? Do I get the emergency family medical leave? How do they essentially interact? And what we now know, and what we all suspected based on the way the statute was drafted, is the plan is that if you're a caretaker, you can combine the emergency paid sick leave and the emergency family medical leave act, benefits, and get 12 continuous weeks of pay. Now again, the emergency paid sick leave is going to be at a higher rate than the Emergency Family Medical Leave Act, so you'll likely get 2 weeks of higher pay before the Family Medical Leave Act kicks in for the remaining 10, assuming, of course, that the child care facilities stay closed for the full 10 weeks. Obviously, if child care facilities open up, that changes the whole thing. It has to be child care facilities closed because of COVID-19. So if that doesn't go the full 12 weeks, folks won't be able to use the full 12 weeks. So it was quite deliberate that these 2 types of paid leave be combined and used together. So if you still have employees on staff and you have folks that are going to have these child care related concerns, they will likely try to combine the 2, and that is permissible. And also, if you already provide paid sick leave, and that's kind of where I'm getting here, you can't use that as a basis to deny this additional paid sick leave. You can't say, I already give you, 10 days off a year, whatever it may be, you don't get this additional benefit. This is a whole new leave requirement under these very narrow circumstances, those 6 criteria for the sick leave, that only is in effect for the remaining 9 months of this year. So you can't force your employees to take their existing PTO in lieu of this emergency paid sick leave. So if they have it already, they get to keep that, and this is a totally new 10 days of additional sick leave that they're being provided. And just a few final questions I want to address from the recent guidance to avoid any confusion. In terms of the FMLA generally, so like I said, maternity leave, people who may take leave for medically serious medical conditions, that has not changed. That remains unpaid. The only paid Family Medical Leave Act is now this Emergency Family Medical Leave Act payment related to COVID-19 and the closed daycare or school. So going forward, if you have anybody else on FMLA or if they're on FMLA leave right now, they do not get to convert that leave to paid leave. So if folks got on maternity leave, it will still be unpaid. Now you can elect to offer them benefits and pay for leave when they're on maternity leave or FMLA leave, but you're not obligated to do so under the FMLA. Under the Family Medical Leave Act, all it does for employees is guarantee that they will not lose their job while they take medical leave. The statute on its face does not provide paid benefits. That's why this is such a radical departure, because we are now for the first time providing these COVID-19 benefits. So your standard FMLA provisions and the way you've treated it in the past will not change. That all remains the same. And the final question I just wanted to highlight here is whether these benefits are retroactive. Can somebody apply it to this week, right now? And the answer is no. The benefits will not go into effect until the act goes into effect, which the DOL has clarified will be April 1st, 2020, so next week. So the benefits are not retroactive. If you have folks trying to get benefits now, they can't. If you lay someone off between now and April 1st, they can't get the benefits. So the benefits are only going to begin once this act is in effect beginning next week. So I know that's a lot to digest, but that is the family's first Coronavirus Response Act. It's been a whirlwind, honestly. It's been official barely over a week, but that's the information we know for now. And it's still going to evolve and change as we get more from the DOL. But to the extent you still have employees on your payroll, and will continue to do so as of next week, this is something you're going to want to be aware of as it will impact your obligations to pay them for certain periods of leave. So as I conclude and just address kind of some final matters here, I did want to address what's called the WARN Act. Now, this is something that's only going to apply to certain gyms, but I just want to note it for folks that are looking at layoffs or large-scale reductions. The WARN Act is a federal act, so again, applying to everybody, that requires covered employers to provide at least 60 days advance notice of a mass layoff or plant closing. This is a federal statute that has its roots in kind of, if you think of the, unionized Detroit workforce days of a whole plant closing, we're moving the whole facility overseas. You want to make sure you're giving folks notice of that. And that's what the statute was designed to do, to make sure folks get notice of a plant closing so they don't show up to work one day and realize it's shuttered and moved. So to be a covered employee, you have to have at least 100 employees. So if you're a gym that has fewer than 100 employees, this isn't going to apply to you. And it excludes part-time employees. So this is going to really not impact most gyms. It's a very small amount, but I just wanted to note it for the larger gyms that may be considering larger layoffs. You're just going to want to consider the WARN Act. There's also state WARN Acts as well, depending on where you're located. They're called mini WARN Acts, but states have these as well. But essentially, what was required, if you're going to do a mass layoff, you can see the definition here. It's a reduction in force. It's a result, not the result of a plant closing, that results in employment loss at a single site during a 30-day period, so that would qualify for now, of at least 1/3 of the employees and at least 50 employees, or at least 500. So for any mega gyms, that could get triggered too, but laying off 500 folks is obviously a massive amount, which is going to require a lot of attention. So if you're a larger gym looking to lay off a lot of employees, you're just going to want to consider this before you proceed to make sure you're providing any notice and avoiding any technical infractions. Now, if you're furloughing employees or your layoff is fewer than 50 employees, there is no WARN event. So again, these are some more exceptions here, which is why it's likely not going to apply to many folks, but I do want to note it. And if the layoff or reduction in hours lasts 6 months or less, there's also no WARN event. There's also a carve-out for natural disasters, which arguably could include the pandemic. A lot of commentators anticipate it will cover the pandemic. We just don't have a court ruling on that. But you still have to provide notice. You just get a shorter time frame to do it. So if you have, and here's kind of a rubric, if you have a larger gym system, you just want to pay some attention to this before you do the layoffs if you're considering that approach, and make sure. So you can see if you have over 100 or more full-time workers and you're going to lay off at least 50 of them, it's going to last over 6 months, you can kind of work through this to see if you're going to provide notice. But the first criteria here, having over 100 employees full-time and laying off at least 50, is likely going to exclude the vast majority of folks. So I don't want to dwell on this other than noting it is a concern. If you're operating a larger gym, just make sure you're looking at your WARN Act considerations. So that is all that I wanted to cover now. There's obviously a lot of other issues swirling, but I wanted to highlight the recent federal legislation because it's created a lot of controversy and confusion, and just try to provide some context to that and discuss some of the staffing options that are available to gyms. I can tell you from having countless calls in the last week, everybody's trying to figure this out and doing it in different permutations. Some folks are laying off more, some folks are doing more furloughs, more reduced hours. It's going to vary by your gym, your workforce population, and of course your financial state. The other thing I just wanted to note here at the end is that Phelps, that's the law firm I'm with, we do have a resource portal. We're putting out COVID-19 updates at this point almost daily, business updates, employment law updates, tax updates. It's all free and accessible. It's just a website. So if you're interested in getting more content on COVID-19 and trying to keep up with some of these other legal issues, I encourage you to check out that resource portal. There's at least at this point 25 different articles that we've put together in the last 2 weeks just addressing various factors of COVID-19 and how businesses should consider responding to it. So if you're looking for more resources, I encourage you to go check that out. And then the final thing I'll say before we open it up is that I've been discussing this with Garnet. We're looking to set up a system here starting as early as next week, where for those of you that have questions or want to talk to an attorney, and we'll take some questions here, but if you have more specific questions about your gym, I'm going to be donating some of my time, and I'm going to make myself available after hours, and some, I'm on the East Coast, so after my hours, make myself available for some pro bono calls. We can set it up where if you need to talk in more detail, we're going to set up probably 20-minute time slots. And if you need to call in and you need to speak to an attorney and you want to get some more advice, I'll make myself available as a courtesy, at no cost, as a pro bono, just to try to help get folks more information and talk through some of these issues. I assure you, they're very challenging. The financial issues, of course, are very dire, but all of the different legal issues and interactions are very complex and challenging. So if you're feeling overwhelmed, I assure you, you are not alone. And like I said, we'll work on getting a format for that out, but I'm going to make myself available for anyone who wants to talk about it further beyond whatever questions we may have now. But that's all I have, Garn, so I'll turn it back over to you and however you want to handle it.
Great, thank you. Just going to pop back over to my screen. And for anyone who wants to get on the schedule for those pro bono calls, you can email info@climbingwallindustry.org, and we'll get you set up immediately. Hopefully by next week, we'll have a more formal scheduling tool in place, and you'll be able to go in and reserve a specific time slot. We have a lot of really great questions, so we're going to jump into those in a second. I was going to ask just a couple clarifying questions that I noted during the call. So I was really glad to hear that you specified that the paid sick leave is an additional benefit that employees are now due, and it will not affect any current state mandated or employer contract based sick leave. My understanding of the Families First Act, the FMLA portion of that is also an additional benefit, so that's not going to affect people's eligibility going forward if they have pregnancies or any medical emergencies.
That remains unclear, actually. It's an interesting question because right now the way that bill is drafted is they essentially took the Emergency Family Medical Leave Act portions and just put it on the end of the FMLA and said, here's another criteria to take leave. So it's unclear if folks will be able to double it up. Now, of course, as a gym, you can always just gratuitously give somebody that leave and say, protected as well, but still waiting to get that confirmed.
Okay. And the other clarification I just wanted to make on there, I think you kind of covered it, but it could have potentially gotten lost for that FMLA benefit. The first 10 days have to be unpaid, just from your general payroll. And correct me if I'm wrong, Jason, but so you can use paid sick leave to cover those 10 days. You could use PTO
Correct.
that an employee might have, but you cannot pay them during those 10 days. Otherwise, it will not be eligible for that benefit.
Well, you just don't pay them under the FMLA, so you can either give them PTO that they've already accrued separately and independent from the FFCRA, or, and what's likely going to happen, is it's also going to trigger the emergency paid sick leave portion of the FFCRA, and you'll pay them the sick leave under that. Yeah. So for the folks that are going to be taking off that Emergency Medical Leave Act, it's likely going to cover all 12 weeks, assuming the schools and daycare stay closed at that time, for the daycare, since we'll be in the summer at that point.
Great. Those are the main comments I had. We'll jump into, we have some excellent questions here, so we'll jump into those right away. The most popular question that we have right now, however, is not directly related to staffing and labor issues. So that question is, do you know the current status on businesses with under 50 employees being eligible for federal assistance? The federal assistance portion of right now, you'd be eligible for SBA disaster loans in pretty much every area in the country. There are a few, I think, that aren't quite eligible yet. The CARES Act that was just voted through the Senate last night will drastically affect the rules around that. So definitely stay tuned to the CWA. We'll be monitoring the federal assistance due to gyms very closely, and we'll be setting up future webinars that are specifically addressing that issue. So I just wanted to make everyone aware of that, and we probably won't address it on this call specifically, but just stay tuned and we'll be publishing information as it's available.
And Garner, just one point to that, because I saw this in some of the questions, and I've had a lot of clients asking this as well. There appears to be, at least in the preliminary congressional drafts, some protections for employers that furlough employees as opposed to laying them off and keep folks on payroll. And in terms of providing certain payroll loan benefits and loan forgiveness, the details of those benefits, however, still remain unclear. We need to see the final version of the act once it gets passed. to better understand that. But the preliminary reports do indicate, and the congressional language so far, that for the employers that keep certain employees on by furloughing them, as opposed to laying them off or still giving them hours if that's a possibility, may be entitled to certain additional benefits, likely to help cover that payroll. So if you're putting payroll towards keeping somebody on, one of the goals of the CARES Act is to help cover that payroll. What type of form that ultimately takes, how long it ultimately takes to get those benefits, certainly remains unknown. There is some language in the bill that has emphasized that it will focus on getting loans and relief out to underserved and rural areas first, so a lot of gyms aren't going to satisfy that, some may, and focusing on, I think, minority-owned businesses, I think, was also one of the criteria they're going to try to look at first. So that may apply to some gyms, but not others. So we don't know that yet, but the final note I'll say on that is, well, that portion of the CARES Act is still evolving, what type of relief you're going to get for keeping folks on your staff. There does appear to be some language to let you bring folks back that you laid off and still get those benefits. There's some language circulating about if you lay off employees but bring them back, you can still try to get some of those benefits. So that's something that we're all closely monitoring, but unfortunately don't have great clarity on yet. And I saw a number of questions in the Q&A on that point, so I just wanted to address that and bootstrap onto your comments there.
Yeah, no, that's great. An additional question that kind of comes off of that answer, on the flip side, is there any potential negative repercussions when it comes to applying for disaster assistance loans or any other future benefits when making the decision whether to lay off, furlough, or reduce hours for employees?
To my knowledge, no, but I would defer that to folks that are more attuned with the business issues and the business attorneys. But from an employment perspective, I think that the big potential benefit or compromise is just certain benefits under that CARES Act appear to be tied to keeping employees on. If it's just getting you more payroll money, it's just going to even out. But we're curious if those benefits are the type of benefits that will help you go pay for operational losses or things beyond payroll. So a lot of folks that I've been counseling through are still haven't pulled the trigger yet on furloughing or firing folks yet. They're still kind of dragging it out a little longer. And I mean, literally things are changing by the day and in the hour at this point. So they're waiting just as much as they can to see the information. And the only real deadline for most folks that we see is the FFCRA gets triggered next week. So if you're an employer that thinks you're going to have a surge of claims under the FFCRA, you might want to make your hiring, and, or I should say not hiring, your staffing decisions before that, because if folks are not on your payroll by that point, they're not eligible for those benefits. But those are the two main timelines that people are looking at. But ultimately, the stimulus package is going to have far greater effect on most gyms than the FFCRA, which will require you to put out the money now, but hopefully get that recouped through the tax credits and all those incentive programs.
Yeah, great. So it sounds like from your perspective, any staffing decisions should not affect SBA lending options. That's my understanding currently as well. And the CARES Act, depending on how it gets passed in its ultimate version, will definitely be weighing in on that. As it's written and as it was voted through the Senate last night, the nuts and bolts of the loan eligibility are basically that you have to have been in business and paying employees before March 1st. So any decisions you make, after that point doesn't seem like it would affect your eligibility, but it is definitely an evolving piece of legislation. So we'll just keep our eyes on it and give you the information after that eventually passes. Another follow-up question on that I don't think you touched on in your presentation, and you might have some clarity here, is when it comes to the rebates and the government assistance for paying for this FMLA pay or any paid sick leave that the employers are paying out, that'll be paid on the quarterly basis, and you don't need to be worrying about waiting for the end of the year to get those funds.
Correct. That's my understanding. Yeah, that's my understanding. I've got some IRS guidance that I can give you if you want to post to the site. The Department of Treasury did issue a little bit of guidance about the rough framework of how that's going to work. And that's what I think. Some folks are waiting on the stimulus package, not only because it's going to have a bigger impact on most businesses, but because even under the FFCRA, if you're having to pay out those benefits, we have a much better idea of how you're going to get paid back and what that structure is going to be. But when we look at the CARES Act, we don't know what it's going to be. I mean, if you're paying out money now, when do you get the forgiveness? When do you get the loans? Are you going to be waiting 12 months, 18 months? You know, so we at least have a little more certainty on the FFCRA, but I have some IRS guidance I can forward you.
Okay, wonderful. I've got a couple questions here. I'm going to combine just so everyone understands some of the definitions and numbers more clearly. So one of the questions is regarding the less than 500 employees / 50 employees. Is that full-time or part-time or both? And another question that is of a similar vein, are part-time employees eligible for any of the Families First initiatives?
So yes, any part-time employees are eligible for the benefits. So in terms of the benefits that are provided, you get just a reduced amount if you're a part-time employee. So your benefits are going to be commensurate with the amount of time you're typically working. So you're going to essentially part-time benefits, so to speak. So yes, both part-time and full-time employees get benefits. And when you're counting up the 500 employees, it includes full-time and part-time. So you don't just count full-time, you count both. It's essentially employees on your payroll is the way to look at it from the recent DOL guidance.
Great, thank you.
But it does not include independent contractors, I should say, just to note that. So if you have route setters that are independent contractors or something like that, it would not include them.
Yeah. This is a really interesting question that you might have an answer for, actually. So someone is under a shelter-in-place order that bars non-essential work. They'd love to take the opportunity to reset their gym, clean the gym, do other operational work in their facility, in their gym. But they're pretty sure this is illegal. Can you speak about shelter-in-place orders and what essential work is?
Well, you're going to want to look at the specific shelter-in-place order that your locality has passed. So it's a local or statewide one, because a lot of them do tend to be a good bit narrower in terms of what's closed than you would expect. And so we've got one down in South Florida in Broward County, and on its face, it's to stay in place, and it looks like it's going to be real broad, and you can't do anything, but it carves out obviously healthcare, it carves out food producers, grocery stores, it carves out construction. So depending on your specific stay in place order, you're going to look at those exceptions and see what's carved out. Now, because gyms, climbing, and fitness and weightlifting gyms, stuff like that, those are all closed pretty quickly. You're probably not going to get a carve out, but I would just encourage you to look at the specific order and see what language is there. There might be an argument that your gym can still have folks coming in, but at least the gym itself is closed, and it's probably going to be considered non-essential at that point. But again, look at the specific order and the language there, because it is going to vary by each order. There's no uniform standards to those. They're all they all differ by every jurisdiction that issues one.
Great. And a follow-up question to that we have in the chat section for areas where there are shelter-in-place orders, does the employer have to lay off or furlough its employees if they're not paying them to sit at home?
No, I mean, if they're sitting at home, then they're effectively furloughed. The jurisdiction has done it for you, so you can just keep them on payroll at that point. For the folks that have benefits, you're still paying those benefits, but otherwise they're not coming into work. It's closed down, so you don't necessarily have to lay them off. You just want to check with your local unemployment office, the state level unemployment, to make sure that's not going to compromise their ability to get unemployment. But in most circumstances, it won't, because not only does unemployment cover the very obvious occurrence where you've been fired, but it can also cover, like we talked about, where you get a reduction of hours or have been sent home for an extended period of time. And as we've certainly seen in Florida and most states as well, the local unemployment offices, or the state level unemployment offices, I should say, are issuing more robust qualifying criteria, meaning that there's more opportunities to get unemployment. So if it's something related to COVID-19, they've opened it up a little more for that. So they're likely still going to qualify, but you would want to confirm that just so they're not negatively impacted by that. But otherwise, if they're not getting paid, they're not working, you can keep them on your payroll. It just makes it easier to bring them back once you do, in fact, reopen the gym and figure that out going forward.
Yeah. And a couple of questions about wording. So I'll combine these two questions into one. Someone's cut 95% of their staff, and they want to know what the difference is between a temporary layoff and a furlough, and then whether that would affect the way that their staff qualifies for unemployment. And another person is asking whether a leave of absence is the same as furloughing.
So to begin with the first question, typically a temporary leave of absence, a temporary layoff will take somebody off your payroll, and you've effectively fired them, laid them off. You have the goal of bringing them back, but it's rarely certain. You still kind of leave that open. A furlough will typically keep them on the payroll and keep them keep them entitled to benefits if they get them. So there's not too much difference than that, but the main one is whether they stay on your payroll or not, whether they're still getting the benefits. That tends to be the main distinction with that. Temporary layoffs, you can certainly give them a target date. I encourage you to consider sending a letter for any of those folks you do lay off or furlough. You want to document that. Not only does that give you as the gym owner a little better protection to make clear when somebody was either furloughed or taken off your staff, saying, no, this person was off payroll as of this date, but it will make it easier for the employees to get unemployment faster by having that document. It often accelerates the process if they have a document that shows this is when I was laid off, it was a temporary layoff, we hope to come back at this date, although it's uncertain, here's the objective, or whether I was furloughed. It can help them, and obviously we're trying to do whatever we can for the employees during this time. So that's a good practice to get into. If you're laying off or furloughing folks, consider putting it in a letter. It doesn't have to be a terribly unique letter. You can find a good form that you're comfortable with and then just start rolling it out to the employees. Typically, I recommend putting in a date that you hope to bring folks back, but qualifying it with language that date is not certain. The date may be extended or adjusted as the circumstances dictate and as the company evolves through this situation, because you may find out when you come back you don't need as much staff perhaps, or things may change at that time. So a date helps to show that the layoff is hopefully temporary, and in certain states that can again facilitate and accelerate getting unemployment benefits. But if you do put in a date, make sure you qualify it heavily to say this is not a date certain. It is a aspirational date, but we will continue to monitor the situation and make sure we act accordingly. So that's what to consider there. And what was the other question with the leave of absence?
Yes, whether an unpaid leave of absence is the same as a furlough.
Well, typically an unpaid leave of absence is triggered by the employee, depending on the circumstances, but generally speaking, they're very similar. It more so depends on what has triggered the event. What is causing the leave of absence? Is it a medical reason? Is it a disciplinary reason, or behavioral, or something like that? But effectively, it's often treated the same because they stay on payroll, they still get the benefits, but they're just not actually getting paid. They're working 0 hours. So it often ends up being the same result, but the triggering circumstances may vary.
Okay. Other than a letter documenting the reason for a layoff or reduction in hours and a plan on an outlined plan on when you'd like to reinstate that person, are there any other resources that gym owners can provide to their staff to help them when they're filing for unemployment?
No, that's really the main thing that you can provide. The layoff letters I prepare, I actually put the link to unemployment. I mean, it's a little thing like that. I mean, most of your staff are, I presume, pretty tech savvy. They can Google it easily enough, but it's just, I make sure that in the letter I encourage them to contact unemployment immediately because they may be eligible. You always want to say may because you don't know for certain what their situation will be. But, you may be eligible for unemployment. I encourage you to contact the office immediately. Here's the link or whatever. That's a nice courtesy to do. But otherwise, the best thing you can often do is give them a letter so they have documentation that they can upload right away and accelerate that process so there's less back and forth involved. That helps. And then, just at a human level, just, be mindful of how you're messaging it to them. You want to certainly remind folks the goal is to bring everybody back, presumably. To bring everybody back, we've just got to make some tough decisions. Because of this, it obviously has a tremendous financial impact, and then hopefully we'll get through this very quickly. I mean, your staff all clearly understand what's going on. You know, it's all in the news naturally, and the gyms are closed. So it's not a surprise, but some of that messaging about the goal of reopening and getting folks back can at least help somewhat in terms of how that's messaged to the employees.
And when it comes to gym owners, what are their typical eligibility issues when it comes to getting unemployment benefits for themselves?
So that will vary by state, but generally it's unavailable if they're an owner. Now, if you're an owner, if you're also pulling a salary, possibly, but generally speaking, owners are not eligible for unemployment. It's just the employees. But again, check with your own state and confirm. But generally speaking, it will not apply. Okay. Or they will not be eligible.
Yeah. When it comes to the Families First initiatives, it seems like those will apply to owners as well, depending on whether they're defined as self-employed or as employees of that organization. Is that correct?
Possibly. Now, under the FMLA, owners generally are exempted and don't get those benefits. So we're going to see if they tweak that, because they talk about the employees, and even though you may also be an employee, you're still at root and owner. So that part does remain undetermined at this point. But even though you're pulling both, it's going to depend on your specific setup. But by virtue of being an owner, that will typically kick you out of those benefits. So we're going to have to see if there's more clarity on that. But generally, the owners do not receive those type of benefits.
All right.
Because I mean, the rationale being in the past is you don't need to protect your job when you go on leave. So this adding the paid element is a big tweak, but it hasn't modified the FMLA and its rationale of protecting the employees so they can come back.
All right, and let's end on a fun one. Someone says 2 of our employees have a child together. Congratulations to them. And are they both entitled to the FMLA benefit? Presuming
that's an excellent question. I would have to research that. Under the FMLA, it is a slightly different modified schedule if both the mother and father leave at the same time. It adjusts the timing for both of them and how it can be used between 2 family members. So that's one I would have to research to see if that gets triggered, but congrats to them. So we can certainly try to dig a little more information on that, but it's likely not. Well, I won't say that yet. Under the FMLA, it would be no, they would have a kind of a combined benefit. It'd be modified for both, but with this paid emergency family medical act leave, where they're trying to get benefits to as many people as possible, it might be more generously construed. So that's what I have to research and confirm.
Okay, great. Thanks for that, and thanks for all of your time, Jason. This is an amazing resource to have. And thanks again for volunteering for some of those pro bono calls. For anyone who missed it earlier, you can email info@climbingwallindustry.org. Which is our general info email address, and we'll try to connect you guys. And then keep an eye out for early next week, we'll have a more defined and robust scheduling tool. There's a couple other questions we're just not going to have time to address. We'll keep those in mind for any future calls. I'm sure we'll have some other calls related to some of the legal issues as some of the legislation passes and some of the rules change. I'm going to hand this over to Laura to just give you an update on what our future communications plans are going to be and what our current coronavirus resource page looks like.
Yeah, thanks, Garnet. So again, in case anybody hasn't been on our previous calls, we're sending out email updates about coronavirus related issues. You can sign up for those emails at climbingwallindustry.org/lines. We're posting on social media. We seem to be settling into a cadence of about 2 webinars a week. I think those are going to continue to happen for the foreseeable future on Tuesdays and Thursdays at the same time. We have a few coming up next week as well. And we've created our centralized hub for all of these resources. So I am just going to go ahead and share my screen so I can show you guys what we have been working on there. So this is located at climbingwallindustry.org/coronavirus. We have our webinars, both the signups for future ones and recordings up here. We have latest news. We have some resources on how you can help us, especially with advocacy efforts. We have an FAQ with answers to some of the most common questions that we've been getting. You can sign up for webinars here again, as I said. We have these recordings. We are posting lots of articles and trying to provide as much information as we can. So those are posted here as they become available. In terms of what you can do to help, we are working on a robust plan to advocate for the industry. You can volunteer. There's a sign-up form. You can also sign our petition that we released yesterday, and that includes our open letter to Congress. We just also released a survey to collect information about the impacts that your gyms have been experiencing economically, so that we can have that information as we're advocating for the industry. And we have the ability for you to contact us to share your ideas if you email us at advocacy@climatewellindustry.org. Just wanted to pull up the petition real quick. We are almost at 7,000 signatures, it looks like. So thanks to everybody who has already signed this, and for those of you who've shared it with your networks and on social. It's really helpful as we're trying to get this information out there. Thank you.
Yeah, thank you, Laura. And let's hear a few more advocacy ideas from Alexandra as well.
Hi there, everyone. So Laura touched a little bit on our advocacy work. I mentioned in a previous webinar that the CWA was preparing a campaign plan and building a coalition. We're now at the stage where we are launching our campaign plan, and we will be activating our volunteers. So if you have not volunteered yet, but you're interested in contributing, please go ahead and submit that registration as soon as you can. I'm going to be sending out messages to volunteers today, mobilizing them with specific roles. Laura also mentioned our impact survey. That's really valuable. I highly encourage everyone to participate if you can. This data is going to be used to make our advocacy work stronger because we'll be able to pull actual data from our membership base and be able to pinpoint exactly the ways in which the coronavirus outbreak has impacted and economically harmed our industry. So if you are interested in more information about the campaign plan, please feel free to reach out to me directly at advocacy@climatewellindustry.org, and I'm happy to share more about that there. We'll be likely hosting an advocacy-related webinar soon enough, so keep an eye on your inboxes.
Thanks, Alexandra. And as always, you can contact any of us with any questions, ideas for future webinars, anything at all. We're here for you to support all of the indoor climbing gyms and also all of our supporting partners such as manufacturers, wall builders, anyone who's related to the indoor climbing industry. Stay tuned for future webinars. Please sign up and join us.